Before we start with the tutorial, we would love to hear your views about today's topic or our tutorials in general. We appreciate the impact we have on your studies, and we wish to learn how we can improve our tutorials for you. Introduction to Law 202 presents the Law of Trust, Trustees and Beneficiaries. What is a trust? A trust can be understood as a legal instrument of its own kind that empowers the owner of the property through a written formal arrangement to allow another person to administer or control such property for the benefit of the identified person or persons. In terms of Section 12 of the Trust Property Control Act, trust property do not form part of the personal estate of the trustee except in so far as he as the trust beneficiary is entitled to the trust property. A trust is recognized as a legal institution sui generis. Despite being a legal entity, a trust does not possess legal personality and cannot sue or be sued in its own name. A trust litigates through its trustees. There are different trusts, and some of them conduct business. Some of these trusts are referred to as business trusts. In most instances, family discretionary trusts acquire assets for the benefit of beneficiaries. They do not necessarily conduct business in the true sense of the word. It is trite that a trust is not a legal person. An inter vivos trust is governed by the terms of a trust deed as well as the provisions of the trust property control. The trustee, subject to public supervision, holds or administers property separately from his or her own for the benefit of another person or persons or for the furtherance of a charitable or other purpose. The purpose for which the trust was established can be ascertained from an interpretation of the trust deed itself. As in the interpretation of a written contract, legislation, or deed, the circumstances attendant upon its coming into existence will provide useful assistance in the interpretation process. The deed will have to be interpreted holistically. Only in the event of a provision in the trust deed leading to unforeseen consequences, the Trust Property Control Act should be considered for application. Furthermore, it is up to the parties to follow the prescribes of the trust deed. Duties of trustees and beneficiaries. The trust estate vests in the trustees and must be administered by them, and it is only through the trustees, specified as in the trust instrument, that the trust can act. It is trite that it is the duty of a trustees to administer a trust for the benefit of the beneficiaries. Trustees must manage the trust property and not the beneficiaries. Section 9(1) of the Trust Property Control, which states that a trustee shall, in the performance of his duties and the exercise of his powers, act with the care, diligence, and skill which can reasonably be expected of a person who manages the affairs of another. Trustees can also be beneficiaries. However, they cannot use their position as trustees to benefit only themselves as beneficiaries to the disadvantage of other beneficiaries. The required duty of care obliges trustees in their representative capacities to deal with trust assets to further the interest of all the beneficiaries. Trustees are not allowed to use their position to further their personal interests. Although a trustee may also be a beneficiary, it must always be subject to the principle that he may not put his personal interests in conflict with his duty as trustee, which is to deal with trust assets to further the interests of the beneficiaries and not to further his own interests. All the trustees can sue or be sued in their representative capacity on behalf of the trust jointly unless one of the trustees has the authority to act for the others through a resolution. As a general rule, proceedings are brought by creditors against the trust through its trustees and not trustees disguised as creditors against the trust and citing themselves in their representative capacities as respondents. For the latter, that would be a textbook example of a conflict of interest. It follows that the trustees should collectively decide whether to oppose proceedings against the trust. This does not mean that trustees in their personal capacity cannot be creditors of their trusts. Where they claim to be trust creditors, trustees must clearly indicate how they became creditors.